Good morning and happy Friday, everyone. Welcome to our live Q&A session today. We're currently streaming on Facebook, LinkedIn, and YouTube, so welcome from wherever you're joining from today. I'm Jenny Lamb, and I'm the Marketing Director here at SJF Law Group. I'll be moderating today's live Q&A and sharing our submitted questions. We have attorney Ashley Tacher here on the live Q&A to answer questions about estate planning. Welcome, and thanks for joining today, Ashley.
Good morning, everyone. I'm Ashley Tacher. I'm an associate attorney at SJF Law Group. Thank you for joining our live Q&A session, and thank you, Jenny, for hosting. So I just want to make a quick note. Please note that we are unable to provide personalized legal advice during this session, so our discussion will be kept at a very general level. So with that said, let's get started.
Okay, so we'll be diving into questions that were submitted in advance. If you're watching and have other questions, feel free to drop them in the chat box. So here's our first question of the morning. Can you explain what estate planning is and why it's important for everyone?
Sure, yeah, that's a great question to start on. So estate planning, what is estate planning? It is the process of preparing for the inevitable and ultimately ensuring that your legacy is secured for the people that you love. And it involves creating a set of legal documents to ensure that your wishes are honored. And every person, regardless of your wealth, which is a common misconception, can benefit from having a clear plan in place for their estate. And it's not just about what happens after we're gone. It's about peace of mind now, knowing that everything will be sorted out for your family.
Wow, that's a great answer. I hope that clears it up for everyone that's watching right now. So here's our next question for you, Ashley. What are the key components of an estate plan?
Okay, so the key components of an estate plan, let's break it down. So typically there are 4 main documents involved in an estate plan. This would include a healthcare surrogate, a power of attorney, a will, and a trust. So I'll go one by one. A healthcare surrogate is a document that designates someone to make medical decisions on your behalf if you're unable to do so. The power of attorney gives a trusted person the authority to manage your finances and your legal affairs if you're ever incapacitated. A will outlines how you want your assets distributed after your passing. And a trust similarly helps manage your assets during your lifetime and after, shows how your assets will be distributed after your passing. However, it offers more control than a will does because it helps avoid probate. It saves time and money for your beneficiaries. So together, all of these documents are the key components of an estate plan, and they all ensure that your wishes will be followed, and they should provide peace of mind for you and your loved ones.
Yeah, thank you for that thorough explanation. I know estate planning can be a confusing process for many people. Now, what is the difference between a will and a trust, and how do I know which one I need?
Great question. So a will and a trust are both very important tools when it comes to your estate planning, but they serve different purposes. So a will is a document that outlines, again, how you want your assets distributed after your death, but it only controls the probate process. This is a court-supervised process that can be lengthy and sometimes expensive, whereas a trust, on the other hand, is similarly a legal document that allows you to transfer your assets to your beneficiaries, but it avoids the probate process, so it's completely outside of court, and it's a process that's managed by a trustee for the benefit of your beneficiaries. Trust can provide more control than the probate process can. It keeps things private and potentially quicker. At our firm, we prepare both will and trust in conjunction with the hopes that the will never gets used. So we typically create a pour-over will. And so what this does, it ensures that any assets not included in the trust for whatever reason, if something ended up going through probate, will end up in the trust regardless.
Yeah, that's a very common concern, and it's great that you addressed it for our viewers. Moving on, I have another great question for you, Ashley. How can I protect my children's inheritance from potential creditors or divorce?
Good question. This is common when it comes to clients. They're a lot of times concerned about their beneficiaries and potential creditors. So in order to do this, I would consider setting up a trust. So a trust can safeguard your beneficiaries' assets and keeps them separate from their personal assets as long as they're held in trust. Assets that are held in trust for your beneficiaries are protected against their creditors while they're in the trust. So this ensures that the inheritance you're leaving them is used solely for their benefit and not subject to claims from creditors or divorce in case of any potential difficulties.
Perfect. That clears it up. For those just tuning in, feel free to submit your questions in the chat box. Now, Ashley, how often should I review and update my estate plan?
Great question. It's very important to review and update your estate plan regularly so that it reflects your current wishes and circumstances, not anything from the past. So changes in the law related to estates or tax may necessitate an update. At SJF Law Group, we offer annual reviews for our client, and we discuss different factors and determine if any updates are required at that point in time to make sure that your documents align with your goals and provide the best protections for your loved ones. So ultimately, regular reviews and ensure that your estate plan remains current.
Wow, those are excellent points. I hope this helps many of you who are planning for the future. Yeah, so let's move on to the next question for our audience. What life events should prompt me to update my estate plan?
That's a good segue into that question. So updating your estate plan. So what kind of events will create a need for an update? So what do we talk about at our annual reviews? Well, we talk about any major life events that have occurred. So this can include marriage or divorce, the birth or adoption of children or grandchildren, any significant changes in financial status. So if you won the lottery, health changes, or the death of a loved one. These are all major life events that could require an update to your documents. So periodic reviews are advised to accommodate any changes in the law or personal circumstances to ensure that your estate plan is current.
Okay, perfect. That clears it up. Thanks for breaking that question down. So here's another great question that someone sent in recently. What happens if I don't name a beneficiary for certain assets?
Okay, so this is one of those lawyer answers that is, it depends. So if you don't name a beneficiary for an individually owned asset, so this could be a bank account that's owned in just one person's name, then failing to name a beneficiary on that account means that that asset will have to go through probate. And so if you have a will, then that probate process is determined by the will, the terms of the will. But if you don't have a will, then they will be distributed according to the state intestacy laws. So in Florida, it would be the Florida intestacy laws. There's a statute that outlines who your beneficiaries are according to Florida. And this might not align with certain people's preferences. So it is really important that you have a will and really a trust, but a will in the case that something does have to go through probate so that it ends up in the right hands. In contrast, for an asset that's owned with someone else, so a co-owned asset like a joint bank account, that situation's different. Typically, and not always, so you really have to make sure, but typically these assets will have rights of survivorship, which means that if one of the owners dies, the surviving owner automatically inherits the asset. So it really depends.
Yeah, it's still an important topic. So people make sure that you still have beneficiaries' name on your assets. Okay, now, moving on to our next question. How can I ensure my beneficiaries are protected if they are minors or have special needs?
Great question. And this is a really important topic. So to ensure that your beneficiaries are protected if they're minors or have special needs, it's really important to consider this when doing your estate plan and bring it up to your attorney. One really effective approach is establishing a trust. So a trust can hold your beneficiaries' share in trust so that it's protected on their behalf. So if it's a minor, they will be held by a trustee until they're of age to take over their own share. And if it's an individual with special needs, then there'll be a constant person managing their share until they are, have reached a responsibility level where they can manage their own funds. So, but for beneficiaries with special needs, a special needs trust would be created and would provide support, and it wouldn't affect their government benefits.
That's great information, Ashley. I'm glad you addressed it for our viewers. Well, here's another good question that someone submitted. What should I consider when choosing a fiduciary?
Great question. This is really important. So, first of all, what is a fiduciary? A fiduciary would be a person that you've named in charge in any of your estate planning documents. So, anyone who has a responsibility. So, if it's in your healthcare surrogate, it would be the surrogate that you name, or in your trust, the trustee. So, when choosing this person, it's important to consider several things. First would be trustworthiness. This person is going to be responsible for managing your assets and carrying out your wishes. So you really want to look for someone who you trust. Another important factor is to make sure that they are organized, detail-oriented. They'll be handling complex matters, so you want to make sure that they're the right fit for that job. You can also consider, most importantly, their willingness and availability to take on the role. So it's a very time-consuming and demanding job being someone's trustee or someone's personal representative. So you really want to take that into consideration. There's a lot of responsibilities, so it's important to choose someone who's capable and prepared to manage all of those responsibilities effectively.
Okay, wow. Thanks for breaking that down so clearly for the audience. I have one last question that someone sent in. What are some common mistakes people make with their estate plans and how can they avoid them?
Great question. So one of the biggest mistakes is something we touched on in a previous question, which is neglecting to name beneficiaries for assets like financial accounts. This is a big mistake people make because they come in, they do their estate planning, and then they open an account down the line and forget to name a beneficiary. And that account has to go through probate. Another frequent error is failing to update the estate plan and following any major life changes. So if you have a child down the line, or if you get into a fight with one of your kids, you want to make sure that you're updating your document so that it reflects your current wishes. A frequent issue that we see on the probate side is that individuals often don't work with an estate planning professional, and that leads to a will that is incomplete or not properly executed. And so we see that a lot of times on the probate side. And lastly, one of the hardest mistakes that we see, and the hardest mistake on us that we see, is when people delay their estate planning until it's too late. So this is particularly when individuals are no longer mentally aware to make informed decisions, and they come into our office typically with their child, but they're not understanding the process. They don't really know what they want because there's no mental clarity there. So It's very important to address these issues proactively by planning early. Don't wait until it's too late. This can help ensure that your estate plan effectively reflects your wishes and it's not too late to actually sign your estate planning documents.
Yeah, that's useful information, and I think it's important for people to know those common mistakes so that they can avoid them from happening.
Right.
And so that was the last question that I've received. We'll give some extra time for people to submit their questions into the chat box. In the meantime, don't forget to follow our social media accounts to stay updated and get other great information. I'm dropping the link to our social media pages in the chat box. You can also visit our website to find blogs and download our free guides. I'm going to drop our link to our website in the chat box as well for everyone. And then if you're looking for consultation, you can call our office directly. Our phone number is scrolling right now across the screen. Doesn't look like there's any other questions for today. So we're going to be ending this live broadcast. Did you have any final words, Ashley?
Thank you so much for joining our live Q&A today. I hope you enjoyed it, and I hope you all have a great weekend. And thanks again, Jenny.
Oh, thank you everyone for joining. Have a great weekend, everyone.